Inheriting a property, it's supposed to be a good thing, right? A legacy. But sometimes it can turn into an absolute legal nightmare. It's an emotional time that gets so much harder when the unexpected happens, breaking that chain of inheritance, entangling families in a really complex legal maze.
So, this is the big question we're tackling today. Imagine this. A property is supposed to be yours, but the person you're inheriting from passes away before all the paperwork is final. What now? The chain is broken, and that clear path forward is suddenly gone.
Here's how we're going to break it all down. First, we'll define what this problem of an interrupted inheritance actually is. Then we'll get into why it gets so complicated. After that, we'll uncover the core legal rules that guide the entire process. Then we'll walk through the 4 essential stages to get it sorted. And finally, we'll look at how some proactive planning can help you avoid this whole situation entirely.
Okay, let's start with the problem itself, what we're calling the broken chain. When a key link in that inheritance line goes missing, the whole process can just grind to a complete halt, leaving everyone stuck and wondering what on earth to do next.
So, the official term for this is interrupted inheritance, and believe me, it's a game changer. This isn't just a small delay. It forces you to start a brand new, totally separate legal process for the deceased heir. Only after their estate is settled can the property continue its journey to its final destination.
And let's just be really clear from the start, this is not a quick fix. Because each deceased person's estate needs its own separate legal administration, resolving an interrupted inheritance can easily, and often does, take several years. It's a marathon, not a sprint.
But why? Why does it take so long? Let's peel back the layers and take a look at the really complex tangle of laws that all come into play. Now, you don't need to be a lawyer, but just looking at this framework gives you a sense of the legal scaffolding we're dealing with. You've got multiple acts, from probate and distribution to land law, and they all intersect. Each one has its own set of incredibly detailed rules that you have to follow precisely. And here in Malaysia, things get even more interesting because of our dual legal system. For non-Muslims, the civil court pretty much handles everything from start to finish. But for Muslims, it's a 2-step process. The civil court appoints the representative to manage the estate, but it's the Sharia court that actually determines the distribution of assets based on Fara'id law. This adds a really critical layer of coordination. I know, it sounds daunting, but the law isn't just a maze of problems. It also provides a clear rule book to guide everyone through. So let's look at the core principles that bring some order to this chaos. Okay, the single most crucial rule is this: you cannot skip a step. The law demands what's called a sequential principle. First, the property must be legally transferred into the name of the deceased heir. Only then can that heir's own estate be administered to pass the property down the line. It's a strict one-by-one process, no shortcuts. This brings us to this brilliant legal concept called vesting, and a 2023 federal court case gave us a fantastic analogy. When someone dies, their legal representative is kind of like a security guard holding a package. The legal title is with them, but the right to that package, the beneficial interest, belongs to the heirs instantly. It's a key distinction that really protects their rights during the whole process. Another key principle is the relation back doctrine. Now, it sounds technical, but it simply means an administrator's authority is backdated to the moment of death. Why is that so important? Well, it legally validates any urgent actions they took to protect the property, like, say, changing the locks or paying critical bills, even before their appointment was made official by the court. Finally, a few other key rules help keep the process orderly. Debts always have priority and must be paid before anyone inherits a cent. If an heir has passed away, their share typically flows by the roots to their own children. That concept is called per stirpes. And as we saw, the deceased religion provides absolute clarity on which court system has the final say. All right, we've covered the what, the why, and the guiding principles. Now let's put it all together into a practical 4-stage roadmap. So here's the entire process at a glance. Stage 1 is all about assessment, gathering those non-negotiable documents like death certificates. Stage 2 is the legal core. You go to court to get representatives appointed for each estate. Stage 3 is the administrative work, paying debts, handling taxes, and executing all the transfers. And finally, Stage 4 is about closing the loop, securing that new title and archiving every single document properly. After seeing that whole process, I think the most important question has to be, can this entire mess be avoided? And the answer is a resounding yes. You see, the real power isn't in navigating the maze, but in preventing it from ever being built in the first place. So how do you do it? The most powerful tool you have is a well-drafted will that names backup or contingent beneficiaries. Beyond that, things like trusts and joint tenancy can also create a more direct path for property transfer. But the two most important actions are to regularly review your plan and, maybe even more crucial, talk about it openly with your family. Your best defense is always proactive planning.
So we'll end with this question for you to think about. While navigating an interrupted inheritance is possible, protecting your family from that difficult journey is, well, it's priceless. When you look at your own plans, is your family's legacy truly secure?